Imagine you see a competitor using a brand name similar to yours, and for years, you do nothing about it. Then, suddenly, you decide to act. Will a court still protect your rights, or is it too late? Acquiescence can indeed defeat trademark infringement allegations, meaning a court might bar you from pursuing your claim. This legal defense arises when a trademark owner, through their actions or inaction, implicitly or explicitly assures an alleged infringer that they will not assert their rights. It essentially means you have given up your right to complain. The core mechanism behind acquiescence is rooted in principles of fairness and equity. Courts consider several key factors to determine if acquiescence has occurred. First, the trademark owner must have known about the infringing use. Second, they must have engaged in conduct that amounted to an assurance, express or implied, that they would not assert their trademark rights against the alleged infringer. Third, the alleged infringer must have relied on that assurance to their detriment, building up their business under the belief that the use was permitted. This reliance typically means they invested significantly in their brand, marketing, and goodwill, believing they were safe from a lawsuit. Finally, allowing the trademark owner to enforce their rights now would cause undue prejudice to the alleged infringer. Essentially, the law aims to prevent a trademark owner from sandbagging a business that has openly invested in a brand for a long period, under the impression that it was allowed. For trademark owners, understanding acquiescence is crucial for proactive brand protection. It underscores the importance of consistently monitoring your market and swiftly addressing potential infringements. Delaying action, especially if you communicate an implied permission, can severely weaken your position later. If you discover an infringing use, consulting with a qualified attorney immediately is vital to strategize your response and avoid inadvertently creating an acquiescence defense. For those accused of infringement, establishing acquiescence requires clear evidence of the trademark owner's knowledge, their implicit or explicit assurance, and your detrimental reliance on that assurance. It is important to distinguish acquiescence from a similar but distinct defense known as laches. Laches involves an unreasonable delay in asserting a legal right, which prejudices the other party, but it does not necessarily requiring an express or implied assurance not to sue. Acquiescence, on the other hand, specifically requires that assurance, making it a more powerful and complete defense if proven. A classic example of implied assurance might be years of inaction after direct communication about the infringing mark, coupled with significant investment by the alleged infringer. The courts carefully weigh these factors, recognizing the balance between protecting trademark rights and promoting fairness in the marketplace. Ultimately, whether you are protecting your own brand or defending against an infringement claim, understanding the nuances of acquiescence provides critical insight into the timeline and expectations for asserting trademark rights. It highlights that consistent enforcement and clear communication are paramount to maintaining the strength and validity of your trademark, while also offering a powerful shield for businesses that have built their brands in good faith with a competitor's knowledge and apparent consent.